forward.
Yeah, come forward. To your left a little bit. Yeah, more. Okay. Hi.
Is this the courtroom that has the accessible doors?
No.
Don't
No, really. Could you hold that?
they have a courtroom with accessible doors?
Thank you. Hold on. Kevin says.
Just describe the layout for me.
So, to your left and to your right are all the chairs just before you enter the court proceedings area.
And the entrance is right in front of me.
Entrance is about 2.5 feet in front of your feet.
Okay. And the table is over there.
There's a table on the left side and the right side.
So as soon as I pass the rail, I would take a left and then a right, like a sharp
Main
left and
seat,
right.
come to order.
But you hardly have to go to the left at all either.
Yeah. So the edge of the table, if I keep going forward, would be there.
You'll be at it in about 7 feet.
Okay, we
The
will
table
call
is
in
at
the
you in
marriage
about 7
of
feet.
Laura Karst and Kevin Shores, FA 11992. Ms. Karst is here and Mr. Shores are here. This is a hearing on, first of all, a couple of remaining motions with Ms. Karst relating to parenting time issues and child support contempt issues. On, I think it was April 4th of this year, Mr. Shores did file a number of new motions, and so I just want to address those briefly first before we do get into Ms. Karst's motions. Excuse me. And so, what the court has in its file is, I believe, 24 original files.
Objection, Your Honor.
Mr. Shores. Mr. Shores, I'm trying to make a record, so I need to do that first.
Okay, ma'am.
Mr. Shores has 24 motions that he has filed in this matter, and I believe it was April 4th of 2019.
Objection, Your Honor.
Mr. Shores, if you want to address the court again, you're going to need to come up to the table to a microphone so that we can properly have a record of these proceedings.
Ma'am,
Mr. Shores,
ma'am, I need to know what I am participating in.
so I just made a record of Mr. Shores, so if you would like to participate in these proceedings,
You're not giving me due process of law, ma'am?
Mr. Shores, if you want to make any further comments on this matter, you need to come to the table so that we can properly...
I am a man. I am an entity, and this court has no jurisdiction over me. I am Anishinaabe Inini, and I have the right to be heard. I have not waived any rights whatsoever afforded to me, my inalienable rights, and also the Constitution of the United States of America, the Constitution of the State of Minnesota, and the ADA rights, Americans with Disability Act.
Right, Mr. Shores, I've indicated to you now twice, and I'm going to indicate to you one final time, that if you want to make any further comments in this proceeding, you need to come to the table so that you can be properly recorded. If you are not going to do so and you continue to have outbursts, you're going
Objection.
to leave the courtroom.
Request of clarification of why is it that I need to come to that table so you can record me, because I can project my voice quite well, ma'am.
Because my court reporter is an electronic court reporter, so these proceedings are recorded by use of the microphones. And so in order to have a proper record of these proceedings, you need to be recorded. If you are not going to do that, then I cannot consider the comments that you are making.
So you are telling me that in this technological advancement where my little digital recorder could pick you up from across the room, that your court reporter's microphone cannot hear me?
Mr. Shores, I've told you now 3 times, but at this point, if you are not going to come to the table, and I will indicate at this time for the record that Mr. Shores is still...
Ma'am, you are in contempt of court and you are violating your position of corpus non judice. Deputies, I demand that you arrest this ma'am because she is violating her position as a judge.
Mr. Shores, if you interrupt one more time, you are going to be asked to leave the courtroom. I need to be
Ma'am,
able to have a
if you
proceeding.
answer my questions, I will gladly participate.
You haven't asked a question.
May I ask them, please?
You can ask one question about these proceedings, but I need you to come to the table.
What?
We can record the proceedings.
May I ask my question then? I have 2 questions, ma'am, before I will come forward.
All right.
The first question is this common law court under the United States Constitution?
This is a district court in the state of Minnesota.
It's a yes or no answer, ma'am.
I have indicated that this is the district court, county of Clay, state of Minnesota.
Is this a court of common law? Yes or no, ma'am?
I've indicated what type of court this is. I'm not going to have an argument with you, Mr. Shores. So no.
Deputies, again, she is violating the Constitution of the United States by not answering that question.
Mr. Shores.
Is this a
Mr.
courtroom of the United States Constitution, ma'am?
Mr.
Yes or
Shores,
no?
I have done with these proceedings in this
You are
matter.
violating
I
your
have-
position.
Mr. Shores, you need
You're
to stop
contempt of
interrupting.
court, ma'am.
Mr. Shores, you've now interrupted me.
Do you have an
numerous times.
insurance policy?
Mr. Shores, you either need to address this court in the way that you've been instructed, or you are going to need to leave.
Explain why. Demand clarification.
I cannot conduct these proceedings if you're going to continue to interrupt me and continue to interject yourself without being properly at the table so that we can continue with these proceedings.
You can't or won't.
I cannot conduct these proceedings.
Why? Clarification.
All right, Mr. Shores, we are going to continue with this matter.
Okay, just know that you are violating my rights of due process and are in contempt.
Mr. Shores, you are not to interrupt this court again. I will give you an opportunity if you wish to speak to your...
I have not given away any rights afforded to me by being here.
All right.
I am just here witnessing. Okay, go ahead, ma'am.
All right. And Mr. Shores, if you interrupt this court one more time, you will be escorted out of this courtroom. Now, as I've indicated, Mr. Shores has filed 24 motions in this matter on April 4th, 2019. I'm going to address those motions as he has filed them. I will just, in the outset, note that all of these motions that are before the court are denied for the following reasons. The first motion that he has made is a motion to vacate a default order. That was the original dissolution order.
Objection.
Mr. Shores.
Then arrest me. Arrest me, ma'am, because you cannot practice law from the bench.
Mr. Shores, you need to leave the courtroom at this point. You've been interrupting this.
Gentlemen, if you touch me, no, I am a free man, an entity. If you touch me, you are violating my constitutional rights as a Native American, Anishinaabe, and, okay, no.
Escort him out.
Let me pull up forward so I can object to this kangaroo court.
No,
I will
the
participate.
judge is done with you.
No, I will participate. You cannot deny me due process. I will participate.
Mr. Shores, I have told you repeatedly that you cannot interrupt this
Hold on, you're gonna hit your
That
toes
all
on
you've been doing at this point.
Hold on, because there's the guy standing right in front of you.
Well, he has to move or
He's
he's
done.
going to get
I'm
ran
not.
over.
I'm not.
Yes, you are, sir.
No, you're done.
Sir, what is his name? Get his name
I'll
because
give
he
you
is.
my name.
No, now
Ryan
you are
Terry.
get it on order.
Get him out.
Judge, you are violating
I'm gonna
your
escort him
rights.
out.
You cannot
Get him
touch
out.
me, sir. You cannot touch me or you are violating, you are trespassing against my rights. Are you a sheriff? Are you a sheriff?
I'm not
Call
answering
your
your
supervisor.
questions until you leave this
Call
courtroom.
your honor.
Escort him out.
He's
Your
objecting
Honor.
and he's ordering me to
Yes.
take-
No,
Take him
he
out.
can't order you. He has no jurisdiction over you.
Let's go. Take him out.
He has no jurisdiction over you. Your honor,
I'm gonna escort him out.
Mr. Shores.
your honor, I'm willing to participate.
Escort him out.
Wait.
I'm willing to
Just give me
participate.
1 second. Mr. Shores, are you going to interrupt this court again?
I will participate, but I will be objecting when it is necessary.
And I will give you an opportunity to
Okay.
do so. However,
Okay?
there are going to be a ground rule. And
No, there are no ground rules
All right.
except the law, ma'am.
Mr. Shores, you have again interrupted me. If you record, and then you will have
You're
an
gonna hit the chair.
opportunity to speak.
Okay,
Are you going to interrupt this court again?
okay, as soon as you're done talking, ma'am, may I ask you when I can properly object then?
When I have given you that opportunity, and I will do so after I get through your motions.
Okay,
Your hand.
so know that I'm here under duress, under threat of incarceration and a threat of losing life, liberty, and the pursuit of property. Thank you, ma'am.
Mr. Shores is now at the table, and so I will give you one final opportunity, Mr. Shores, to participate in these proceedings. You need to listen to what I have to say, and then I will give you an opportunity to respond once I am done. So as I've indicated, the motions that were filed on April 4th, 2019 are denied. As it relates to the motion to
Ad.
vacate
Don't
the
mess with Mother
order,
Earth. Shut on
that was
iPhone.
denied because of the fact that the Court of Appeals, first of all, already ruled on the issue of whether or not that was a proper order, and whether or not Mr. Shores was afforded an opportunity to participate, and so that motion is denied. There's been nothing brought before the court that indicates that this matter should be vacated. As it relates to motion number 2, which is a motion to vacate a contempt order, that is denied simply because the court has not issued a contempt order at this time. As it relates to motion 3, which is a notice to the court contesting the support order made in violation of due process, judgment by persons not a judge or void, that issue was previously addressed and denied in my order of December 24th, 2018. As that order indicated, Judge Cahill is a district court judge, not a magistrate, and he is the one that issued the child support order in this matter. As it relates to the notice to inspect and review records related to a debt, that was addressed to the child support office. As it relates to a change of venue from state court to court of record, that is denied as this court has jurisdiction and venue is proper in this matter as we are a district court. The notice of a petition for injunction is denied. The respondent in this matter is claiming that a non-4D agency cannot do income withholding. However, the dissolution order was very clear that ordered income withholding pursuant to Minnesota Statute 518A.53, which applies to all cases where child support is ordered. There is a notice to cease and desist violation of income withholding. Again, that was submitted to the child support office. There is a motion to challenge, and as it relates to custody, that is denied, as Judge Cahill's prior order of October 18th, 2012 made very clear, detailed findings regarding custody and parenting time. That decision was appealed and affirmed, and there has been no other proper motion before the court as it relates to custody or parenting time. There was a withholding funds from federal income tax to satisfy a past due support. That was to the Office of the Secretary of Treasury, so the court is not taking any action. There was a demand for dismissal for lack of personal jurisdiction. That is denied, as this was an original Clay County matter. Both parties resided and continue to reside in Clay County, Minnesota. The respondent was properly served with the motions for contempt and parenting time assistance, and so the court does have personal jurisdiction over this matter and over the respondent. There was a notice to the court contesting the support order for being void for quorum non-justice. I would note that this is the same request as one of the prior motions. It was already addressed in the December 24th, 2012 order. Judge Cahill is in fact a district court judge, and so that matter is denied. There was a demand for dismissal, support order outside the jurisdiction of 42 U.S.C. section 666. Again, this was to Clay County child support. There was a notice to the court to demand for dismissal as this court does not have jurisdiction to enforce child support. That is denied as Minnesota Statute 518A.39 allows the court to modify child support. Minnesota Statute 518A.72 gives the court jurisdiction to find an obligor in contempt for failing to pay child support. There was a demand for bill of particulars in a criminal case that was first addressed to the acting county attorney, and so I don't believe that this is a motion before the court, but if so, it is denied as this is not a criminal action. There is a notice of motion to vacate an order of contempt on the grounds that the judgment again, is by a judge quorum non-justice. Again, this appears to be a consolidation of many of the motions. As I've indicated, there is no contempt order as of this time. That's what we're here for today to determine. And Judge Cahill and this court are both district court judges. There was a notice to vacate the order of default for failure to prove willful violation of support order. Again, there are a number of things that are addressed in that is denied. If there was a request in that because there's a default order in the dissolution action, that was already addressed. I also already have noted that the respondent was properly served with these motions on October 10th of 2018. Initially, the respondent filed 34 motions in response to that, has appeared in court on a number of occasions related to these issues, and the court has not taken any action on the substantive motions that were filed. There was a petition or a motion to vacate the order of contempt. As I've already indicated, the court has not issued an order of contempt at this point. That's what we're here for today. There was a cease and desist collection action by a child support agency that was to the Clay County Child Support Office. There was a notice of motion, demand dismissal for this state and tribunal lacks personal jurisdiction. I've already indicated that personal jurisdiction does exist, and so that motion is denied. There's a notice to the court for demand for dismissal of the court as the court lacks consent from the respondent and must prove personal jurisdiction. Again, I've already addressed that, and so that motion is denied. There's a notice of motion objecting and demanding clarification by this court to prove jurisdiction to subject respondent to the child support enforcement proceedings. They've already indicated this court does have jurisdiction as it relates to both child support contempt, child support matters, as well as the parenting time matters under 518.175, 518.18, and 518.1751. And so that motion is denied. There is a notice of a petition demand to vacate a support order in violation of the expedited process. Again, that motion is denied. This matter has never been in the expedited process. This matter has always been before the district court. There was never a magistrate that was assigned to this matter, nor did a magistrate ever make any determination in this matter. This was an original action that was decided by Judge Cahill. That action was then appealed to the Minnesota Court of Appeals. That order was upheld by the Minnesota Court of Appeals. There is also a request in that notice or petition for a right to, or a request for a jury trial. As I indicated in my December 24th, 2018 order, there is no right to a jury trial in these proceedings, and that motion is denied.
Can you repeat that, please?
Of arrears, notice to inspect and review records related to debts. That also was to the Clay County Child Support Office. There was a notice to the court, objection, demand proof of valid court order to prove contempt of court. Again, that was a argument that he could not be found, that the respondent cannot be found in contempt of court because it is a void judgment by a judge that is not a basically legal judge. Again, for all of the prior rulings, as well as the fact that this was addressed in my December 2018 order, for all of those reasons, that motion is denied. I would also note that on April 19th, 2019, Mr. Shores then filed, I believe it was four or five new documents and petitions. Those are untimely, and as the court needs at least 14 days before a motion hearing in order to address motions.
What motions were those, ma'am?
Those were, as it relates to a petition for writ of habeas corpus, there were some other requests as it relates to, they were, well, what I will tell you, Mr. Shores, is that they were duplicates of the motions I've already addressed, except for the petition for writ of habeas corpus. I'm not considering that today because it was not promptly or timely filed, but I will also note that I already denied the writ of habeas corpus in my December 24th, 2018 order. So I believe I've already covered it, even if it was to be addressed. So,
Your Honor, may I say something? I was never properly served the last, I think, 22 motions. Kevin emailed it to me, and he has the order of disability accommodations that I should email him, but he should be emailing me. Having service
4 p.m. Monday.
usual
Stop.
in Minnesota.
Stop.
I was, and thank you, Ms. Karst, I was going to address that as well. Because I was denying the motions, I understand your position is that you were not properly served with with any of the last motions that we received. And so I have denied those motions. However, I would just note that if there are any motions to be filed in this matter, Mr. Shores, you need to do so. Okay.
Objection, ma'am?
Yes, Mr. Shores.
Okay, when you started this, you said that you wanted to talk and then you would let me talk.
And I was going to give you that opportunity in just 1 second.
Okay, but you let Ms. Karst talk. You are being unbiased and releasing and relinquishing your position of a judge if you continue to practice from the bench.
All right. So, as I've indicated, if there are any
Objection,
future
can you
violations-
clarify or add to that statement, ma'am?
No.
The
If-
14th Amendment of the Minnesota Constitution?
Mr. Shores, you need to let me finish what I'm going to finish, and then I'll let you go forward. So as I've
Okay.
indicated, under the rules in this matter, all filings must be done by mail to Ms. Karst. There is an ADA order out there that requires Ms. Karst to send any motions or documentation to you, Mr. Shores, by email pursuant to the ADA. And so she is required to do that. You need to serve her by mail.
That is objection again.
All right. And I'm not addressing whether or not service was proper in this matter. I'm just addressing the fact that if anything future is going to be filed, that's my understanding of the order. So, Mr. Shores, I've indicated all of the motions that you have filed in this matter are denied. And so, as it relates to the last two issues that we have then, as it relates to child support contempt and...
Objection, Your Honor. How can you, explain this to me, how can you talk about all those motions and you say you denied them and you just brush over it and continue on to the next matter at hand? We need to stick to addressing the motions before we start anywhere else, ma'am.
But you filed your motions, I've addressed all of them.
But ma'am, I have asked for them in writing.
I understand that, the court is not required, that's why I went
Yes,
through
you
all of
are,
them.
ma'am, because if I want to take this to a higher court, then I need it in writing that you are denying and dismissing my motions. And your original order of the 24th, I object on it because of the financial hardship of my benefits being stolen from me. I have not had due process of the law. I have had rarely any assistance whatsoever beyond the subcontracted merit care. I had a financial extra that I utilized to pay out of pocket somebody to help me with my daily living activities. Because of this court and its trespass against my rights and my life, liberty, and my property given to me by a VA benefit, Social Security benefits that are awarded to me for my health, yet this entity known as Laura Helen Karst is wanting to take away a disabled veteran's benefits. And out of those benefits, there is a certain portion that is allocated for children. And Mrs. Karst is already getting well above that allocation from the VA benefits and the Social Security benefits. And because of this hardship, I demand that this court be adjourned and I get my due process of law and again a contingency, because I have not been able to address and condemn and object to your December 24th order, because I've had rarely any assistance.
All right. Your objection is duly noted for the record, and we will be proceeding today. So, Ms. Karst, they are your motions.
Objection, ma'am.
Mr. Shores.
I want to address the writ of habeas corpus.
We have addressed that. I am
No,
not going to
we
go-
have-
Mr. Shores, you are not to interrupt me again. If you interrupt me one more time, you will be told to leave this courtroom.
How, ma'am, I am not going to due process if you're not answering my questions. How is that due process if you're not answering my questions, ma'am?
Mr. Shores,
Clarification.
Mr. Shores, this is not a dialogue between the court and you, or between the court and Ms. Karst.
But then
These
you're
are
practicing
motions
law from the bench. This is supposed to be about me and this entity and our children.
Mr. Shores.
Isn't
I'm
that what we're here
resting on-
for?
And that's what we are going to
The
address.
betterment of the
All
children?
right, Mr. Shores, you have now interrupted me again 2 times, and so you need to refrain from that. Ms. Karst, these are your motions, and so we can address first the parenting time issues that you've addressed, and then we can address the contempt matters. So as it relates to your request for a parenting time expediter as well as other requests regarding parenting
Objection.
time, Mr. Shores, you will have an opportunity
Okay.
to also respond to what Ms. Karst's arguments are. So Ms. Karst, as it relates to your motions, I've reviewed your motions as well as the documentation that you have provided. Are you still requesting all of the items that you have indicated in your prior motion?
Yes, I am.
All right, one of the requests was for some compensatory parenting time related to some time that you didn't get.
Your Honor, I forgot about that, and Kevin did allow me that parenting time, so that issue is no longer on the table
All
anymore.
right, so there is no issue as it relates to compensatory parenting time.
Objection.
Mr.
When,
Shores,
ma'am, okay.
you can have an opportunity to speak when Ms. Karst is done presenting her arguments to the court. So, Ms. Karst.
So yes, in relation to number 1, I don't need any compensatory parenting time.
So then, I'll go through your motion.
Okay.
All right, so the second request that you have is appointing a parenting time expediter. Are you still requesting a parenting time expediter?
Yes, I am.
And so I have a question for you and Mr. Shores. You're going to have an opportunity to respond to the same questions once I get to you, but I need to know what Ms. Karst's position is. As it relates to the parenting time expediter, and I know we kind of went backwards because Judge Cahill had originally ordered a parenting time expediter, and I had said we need to come back here because there were some issues with service and I needed to make sure all of the issues were resolved at this hearing. But I don't know if anything had occurred with regard to getting a parenting time expediter under that prior order.
Your Honor, we were ordered to select from a list of parenting time expediters, 2 expediters that we would be willing to work with. I selected my 2, and I also said I would be willing to work with anyone on the list, and I sent them to Kevin. Kevin sent me back something that said I needed to cease and desist and no longer contact him regarding this. He would not select a parenting time advisor, and that's where things stood as I waited to come back to court.
And so you've indicated some reasons for your request for a parenting time expediter in your motion. Is there anything else that you want me to consider as it relates to that issue? Or why a parenting time expediter should be appointed in this matter?
Yes, besides everything that I've listed in my filing, I would just like another person that is an outside, non-biased person looking in that's kind of taking record of everything that's happening. Also, I want to say that I'm one step away from asking for a restraining order from the court for Mr. Shores because I cannot live my life this way anymore. Every time that he disagrees with me on schedule, I go through threats, insults, bullying.
Objection, hearsay.
Called to my house, and I can't live this way anymore.
Objection, hearsay.
Mr. Shores, first of all, Ms. Karst is simply providing me with arguments, and so...
Well, where's the evidence, ma'am?
All right, and so...
I
Ms.
do
Karst, you
have
can
evidence
continue.
that I would like to enter, exhibits that I would like to enter into evidence. I'm not saying I want you read at this moment, but I do in regard to this issue and the things that I have just said.
Objection.
Evidence, but-
What is your objection, Mr. Shores?
That if she is bringing in anything of text messages, then the entire history of text messages have to be scrutinized. And going back to the original court order, if Judge Cahill is not giving me due process of law, then any order by him is not valid. It has been noted finally in this court about proper serving of papers, which did not happen at all with Judge Cahill. Mrs. Kars is not properly serving me papers now.
Objection.
In the order by the judge out of Detroit Lakes, he said that it was for the courts to send me information. My understanding that Ms. Kars was supposed to send it to the courts, and then the courts were going to scan it and send it to me. Not only did she not follow that, but she sent it to an original one email that the court and she was informed not to use anymore. Therefore, there were many things that she sent that weren't addressed because I specifically created an email specifically for all matters dealing with this court.
Your Honor, I was never given
And so
an email
these-
specifically
Ms.
to
Kars,
address
you
Mr.
need
Shores.
to stop as well. We can only have one person talking at once. And
So I cannot address any of these things that she calls evidence because, as I have told you, ma'am, I have no extra help to help me through this matter. I have not had any help since January.
all right, and so I have just pulled up the order on disability accommodations, and that simply indicates that all parties to this case shall email Mr. Shores any filed documents in the same manner. That does not indicate that Clay County Court Administration is going to send those, and in fact, we do not, Clay County Court is not in the business of doing service, and so under that order, Ms. Karst was to email. I do note that there are affidavits of service in this file as it relates to all of the motions. I note that Mr. Shores has filed in excess of 50 motions in response to Ms. Karst's motions, and so that's denied. So Ms. Karst, you can continue.
How can you?
Your Honor,
That's practicing law from the
in
bench.
relation to the order on disability accommodations, I also was never given a specific email address to email Mr. Shores.
Ms. Karst, I'm going to stop you for just a moment. If you could move your microphone back just a little bit.
Sure.
Give us some feedback. Thank you.
So
Objection, there's proof that she already
Mr.
sent
Shores.
emails to the, okay.
Mr. Shores, you need to let her finish as well. Again,
Okay.
as I've indicated, we can only have one person talking, so Ms. Karst.
originally I sent them to all 3 email addresses that I know of, just so that I could be sure he received them. And then recently he texted me an email address he wanted me to use, so I've since started using that one. That was the first time I was ever given that email address. So going back to what I was saying before I was interrupted on the restraining order, I was saying that the other reason I want a parenting time expediter is because we're parents together, we have to make arrangements, we have to make schedule changes, and there's no getting away from that, so I need someone to speak between us, because if not, I need a restraining order, so.
And so the issues that you have addressed in your motion have, as we sit here today, not been resolved. You have not been able to resolve them with Mr. Shores.
Not at all.
She has not
So-
tried, objection, she has not tried to resolve them with me.
All right, so let me ask you this, Mr. Shores. There is a request for the courts to appoint a parenting time expediter to help the parties resolve any ongoing parenting time problems or any future parenting time problems. Are you in agreement or in disagreement?
I'm in
with the court?
disagreement with it, ma'am.
Then you can tell me anything else that you want me to know as it relates to that issue, or why you disagree with it, other than what you've already indicated to me.
Okay, first of all, I disagree with it because Mrs. Karst is in contempt of the court and lying to the court, because from the beginning, she said that we would have equal parenting custody 50-50. From the beginning, from the get-go.
Well, and Mr. Shores, I would just like you to know that there is a court order out there now addressing parenting time and custody, and so that trumps any agreement that Ms. Karst has. So, and
Excuse
any
me,
other-
ma'am?
There is a custody and parenting time order out there. That's the same order that Judge Cahill issued on October 18th, 2012 that addresses custody and parenting time.
Okay, and can the court show in evidence that I received that order?
Yes, I can tell you that you appealed that order, and that order was upheld by the Minnesota Court of Appeals,
It was appealed by who?
by you.
Or was it appealed by a lawyer that has been disbarred because of an addiction of Adderall?
It was appealed, well, by you. So anyways, as it relates to this matter now, anything else you want me to know as it relates to the parenting time expediter?
Right, ma'am? All I want, excuse me. I object to all of these proceedings, that they're absolutely violating my inalienable rights, my constitutional rights by the state of Minnesota, the United States of America, and the ADA. And Mrs. Karst, throughout our partnership, has continuously violated those rights and does continue to do that. And is fraud a crime, ma'am?
Again, Mr. Shores, I'm not in the business of answering questions. I need to get information from you as it relates to these motions and what your position is on the different motions that have been brought before the court. Any arguments that you have?
I told you I can't address the motions, ma'am. I have no assistance. So how am I given due process of law?
You are here today to address the motions, and so if there are any further arguments that you have as it relates to the parenting time expediter issue, this is your time to tell me what those objections are. You've already indicated,
Well,
Mr. Shores, just 1 second. You've already filed and indicated a number of different things that I've denied. So as it relates to that parenting time expediter request, anything else that you want me to consider?
Mrs. Karst is a very intelligent person. I am a very intelligent person. We have a bond between us, which are our blessed gifts of Infinity and Spheria. And Infinity wants to be here, but is afraid of the court system, and also has commitments of being in a play. My children have stated many times all they want is what is fair and equal and right. From the beginning, this has not been Mrs. Karst's position. Mrs. Karst is getting paid to have extra time with the children. Any more fraudulently taking of my benefits, my disabilities, is causing me major strife. And it is a violation of my rights to take any more money. So if she wants this, then she should pay for it.
All right, Mr. Shores, we're not talking about the child support issues right now. We're talking about parenting time issues. And so this was related to a parenting time expediter. As it relates then to the next part of your motion, Ms. Shores, you've indicated that you're asking for to change the existing parenting time or visitation order as it relates to transportation.
Yes, Your Honor. You know, I really should have offered my exhibits, and number two, would I be able to still offer my evidence?
Well, you've indicated that you have text messages, and so
I have other things too. Like I was supposed to enter an exhibit A and B, or it's the wrong folder. One moment, Your Honor, I'm sorry.
Well, while you're looking for them, I have a question for you, Ms. Karst. Are those, I know that in the initial motion that you filed, you had a number of exhibits that were attached to that in the form of email, or exhibits with emails and text message conversations.
Yes.
Are those the same things that you have here?
Yes,
All right.
that is mostly what I had, and then I also have some various journal entries that I made at the time of.
All right.
You're-
of
you're-
Okay, so I will just tell, Mr. Shores, 1 second. Ms. Karst, I will tell you that when the court makes rulings on this, I have to consider anything that's been filed. So I will consider the affidavits as well as all of the things that have already been filed with the court. All right, so if they're the same things, I don't need to receive them again.
Oh, okay, because I called in and was informed that I was supposed to offer them in court in order to file them, but I misunderstood. I thought when I served them, I needed to serve a copy to Mr. Shores and the court of everything, so,
And so we have those in the file.
okay, now I do have filings. I did enter affidavits for exhibits, let's see, N, O, P, Q, and R, and those I do have it because I didn't file
Objection,
those.
Mr. Shores,
I do not know, as I've stated, I do not know what exhibits and stuff that she has, because as I told you, I have not had adequate assistance to deal with these things that have been sent in the last month.
all right, none of this was
I am-
sent, well, Mr. Shores, I will indicate to you that none of this has been sent in the last month. This is all things that were sent back in August of 2018 that the court has. Ms. Karst,
Your,
are those
Your
the-
Honor,
Mr.
but-
Shores, just 1 second. Ms. Karst, are those the exhibits that you were referring to?
No, the ones that I have already filed were filed back, the ones that I filed with the court were filed back then, but these new ones I'm talking about, I didn't file those with the court yet. Those were served to Kevin on April 15th and 16th.
All right, and so I'm not going to consider those because of the fact that we're here for the hearing today. I will consider anything that was filed as well as any arguments that the parties want to make on anything as it relates to the motions. All right?
Your Honor,
Your Honor, what is the final date before court that we can serve?
Well, any
Any
new
procedures?
motions have to be 14 days prior to the hearing. Any additional things have to be, I
These were
think
not-
it's 7.
Okay.
And so his motions were filed 14 days before the hearing, and so that's why I'm considering them. Obviously, everything else was filed long before that, and so I'm considering those.
The new evidence that I wanted to admit was about the VA questions that you had for me at our last hearing. I wanted to present evidence proving what I was saying to you.
And as it relates to child support, that's going to be the contempt issue, that's going to be different. That's why we're going to address that second, because
Oh.
for that matter, I'm going to have to take, that's a different issue where we're going to have to take testimony and things like this. This is
You're-
simply for arguments for the
And
court.
actually, I guess everything except my last piece of evidence was for the contempt.
All
I'm
right,
sorry.
so we're not addressing that yet. So we need to get through your first motion. So you've made some requests for.
Your Honor.
Mr. Shores, just 1 second. You've made some requests for as it relates to transportation. And you are asking the court to issue an order that provides that Mr. Shores needs to provide transportation for his parenting time.
Yes.
All right, so Mr. Shores, what is your position on that request?
Your Honor, Mrs. Karst lives in Hawley. And I, at the top of my head, I can't remember if that is in Clay County,
It is.
but it is 25 minutes away from school, where the girls go to school in Moorhead. Laura picks up the girls at 8 o'clock at night and then drives them to Hawley, getting there roughly almost at 9 o'clock. And then the girls have to do what they have to do to get to bed. My friends are consistently telling me about the huge bags under Infinity's eyes. They then have to wake up around 6 o'clock in the morning in order to get to school on time.
All right, so Mr.
If,
Shores,
I can't finish talking?
I have a question for you. I need to know how this relates to the issue of transportation and who should be doing the transportation.
But if you, so you can interrupt me, but I can't interrupt you.
Because I need to only consider relevant issues.
It's all relevant,
information.
ma'am. I will come back around. This is how I speak as a Native American. We talk in circles, but I promise you I'll come back.
All right, so how does this relate to transportation and who is covering the transportation?
So, if the children were at my home during the school day, then there is no issues of the tardiness that my daughter has, the detention my daughter has, and the fear and the anxiety and the lack of sleep in the morning. I do at least provide when I can, because as you see, it is hard for me to drive. I am blind and confined in a wheelchair with limited dexterity. And for me to get somebody to drive, that causes me more financial burden. And as stated, as of now, the VA is taking away all of my disability, all of it, starting in May 1st.
And Ms. Karst, you're gonna have an opportunity to respond, but I need
And
to-
so how, because even today, with the individual that brought me in today, I have to compensate them with gas, as I told them, to get me here today. When I come here, I am paying people to bring me here. I am paying people to address these court matters, which is causing me financial burden. So, under the guise of the law, if it was equal parenting time, then Mrs. Karst would not be receiving the money she has. Then I would have money, and I would gladly, if I had the money, because when I do have the extra money, ask Ms. Karst if she receives cash awards from me when I have extra money.
All right, and so I understand your concerns as it relates to the driving issues. As it relates to the next issue, which is a holiday schedule as well as a summertime schedule, Ms. Karst, it's my understanding that you're asking the court to issue an order to include holidays and summer parenting
Your Honor,
time.
do we miss number 3? I believe.
Sure, mic off, Ms. Karst.
Have we?
Green
Oh,
light.
okay. Yeah. Okay.
Oh, I did.
Okay.
All right, so let me do the holiday parenting time, then I'll go back. So you've also made a request.
May I ask a
for
question first?
Parenting time.
Ma'am,
Mr. Shores.
I have a question, please. Now, it was just informed that her microphone was off. And earlier you stated that your court reporter needed the microphones in order for her to do her due diligence. Are you lying to me, ma'am?
Mr. Karst, that's why the request was made to turn the microphone on.
Mr. Shores.
Mr. Shores, excuse me.
That's Mrs. Karst.
So that we have. a
Justin
proper-
Karst used to be my ex-best friend.
All right, thank you, Mr. Shores. So, Ms. Karst, you can continue with regard to your request for holiday and summer and school holiday parenting time.
On the holidays, our parenting time order did not specify what we were supposed to do during holidays, and we constantly disagree on whether we're supposed to switch from who had them the last year on that holiday or who had them the last holiday as things switch. And I think that it would be very helpful for our parenting time order to specify something like Laura odd years, Kevin even years, or something like that, and have the holidays listed for the school holidays, which is E on this list, is the same exact thing. And I would like some kind of an order on how we should split those days. Because right now it would be, again, it's who had them the last day off or who had them the last holiday, and then we can't agree on that. And then D, for summer, our parenting time order doesn't specify a schedule for summer other than the order that the parenting time for Kevin starts at noon on a non-school day. And I would like to have a clear order of what parenting time, what it should be, what time it should start over the summer, and how we are supposed to divide that time, because it's never, ever gone smoothly.
All right. Mr. Shores.
Your Honor, I have suggested numerous times, asked Laura, because of my situation and my disability, I have to adhere to a schedule. I have people that are subcontracted by the VA to come into my home to help me with my daily living activities. And so I have requested many times of Laura to give me 3 weeks in advance. I have presented her different avenues of scheduling to agree with, yet she does not address them. I suggest that over the summer, we just do a 3x3. And that would be the easiest. And then if there is summer plans, if we are notified well in advance, because according to this so-called court order that is not valid, it says if no agreement can be made over the holidays or the times off, it goes back to the original schedule. And so that's where I go. I inform Mrs. Karst. I'm like, because I would ask, and I can show evidence of the fact that I have asked in advance, what are your thoughts on this, or this date, or this holiday? I just graciously, over Easter, because I was informed that her mother was coming up for 2 days, I offered to switch the weekends on a last minute note Friday morning, and Ms. Karst had no objection to that. So it is proven that we can work together, but it's when is she willing, when it's convenient for her, in my experience. I would love to say, okay, by next week, Mrs. Karst have the whole summer plan, because I've already been working on the summer schedule. Because there's a lot of factors in. Our 15-year-old turning 16 this summer, she should have already had her driver's license. Because of the special circumstances of me being disabled, she can get them early. I would like to give her more freedom so then the driving would not be such a challenge if she had her own vehicle or access to a vehicle.
All right. Then as it relates to, I missed number 3, so I'm going to go back to that. Ms. Karst? Yes.
We forgot to address weekends and telephone contact under this number. I'm sorry, I didn't turn the page and I realized that
There is not, I don't see anything.
Oh, I see.
Your-
Never mind, that is under the next number.
Your Honor?
I see nothing under telephone.
Your Honor, how am I able to follow along this and have due process of what you guys are talking about?
I'm addressing each and every motion that she's brought, and I address it to you as well, Mr. Shores, to tell me.
But where
if
were
these
these
are-
motions? Where were these motions?
These motions were filed in August of 2018, so. Ms.
Okay,
Karst.
is there a certificate of delivery?
Yes. Now, Ms. Karst, the next motion that you have is, as it relates to, you are making a request to change the existing parenting time visitation order to require supervised parenting time.
Yes.
Is that still a request?
Yes.
All right. And what is your request as it relates to that?
Kevin has begun to include our oldest daughter, Infinity, who turns 15 this July, on our text conversations. I refuse to have arguments in front of her or either of the children, but he continues to try to engage me in arguments in front of them.
Objection.
He-
All right, Mr.
inappropriate-
Carson, just wait.
Objection.
Sorry, Mr. Shores. Ms. Carson, you need to wait a second. Mr. Shores, I'm going to give you an opportunity to address this, but you need to let Ms. Carson finish her arguments to the court. So,
Objection irrelevant.
well,
How is text messages have to do?
all right, Mr. Shores, I'm sorry. I understand your position. You need to let Ms. Karst finish. So, Ms. Karst.
He has inappropriate conversations with girls, telling him he wants them to sit in on court, playing them audio transcripts of our court proceedings or his own audio recordings that he's taken in this courtroom. He tries to involve the girls into arguments. I believe that he no longer cares or is willing to try to control his behavior in front of the girls. He says things in front of them that he shouldn't say. I've asked him to communicate only through email and text message, and now he's starting to include Infinity in on all of those messages too. So now I can no longer protect her from the things he's saying to me because he's saying them right in front of her in writing. Our parenting problems this is ongoing. This has no indication of getting any better. This has been 7 years. And I was hoping that these issues would get better, and instead they have appeared to be just getting worse. I asked for Mr. Shores to pay the full cost of the expediter because it would be a hardship of myself and my daughters, and the full cost of supervised parenting because it's as a result of his behavior that we need something like this.
All right. Mr. Shores, as it relates to the request for supervised parenting time, is there anything else that you want me to consider?
Your Honor, as an Anishinaabe, when a woman gets her menstrual cycle, she is a woman. She has the opportunity to create life, an incredible responsibility of a woman. According to our teachings, as a woman, she has the right to know about her life and all decisions that are made, even though in this dominant society they say until 18 they're an adult. But as an Anishinaabe Ikwe, she is a woman. And she has the right to make decisions, to be part of the decisions. And I've asked Mrs. Karst, if there's anything in this world, if she wants me to be honest and wants me to act in the most optimal, responsible, humble way, it is in front of my daughters. My daughters are my life. They are the light in my darkness. I am humbled before them and always act appropriate. We have a swear jar where they get $1 if I swear. That has been their entire life. I can bring many a witness that can validate how my daughters are so sacred, as should be known. So I am absolutely abhorred that Mrs. Karst would placate to such words.
All right. Then as it relates to your request, Ms. Karst, for changing, well, not really changing it, but basically your request that the prior order had the ending of the visitation or parenting time at 7 p.m. on Sundays.
Yes.
And you're asking for the court to enforce that because it's not occurring at this time.
Yes, and I would like to know what I should do when that happens because it happens every time.
And so the court order is out there at 7 p.m. So, Mr. Shores, as it relates to...
701-846.
Sorry, ma'am.
7. Slide to answer. Message. Message. Slide to answer. Remind me. Dodge. ND. 7. 0. Dodge. Slide to answer. Message. Message. Button. Slide to answer. Message. Message. Button.
So, Mr.
1 second, ma'am. Sorry. Turn on Do Not Disturb. My apologies. I thought I did that already. Can you repeat that last thing, ma'am?
All right. So, as I indicated, the court order right now indicates that parenting time is ending at 7 p.m. on Sundays. Ms. Karst is indicating that you are not ending the parenting time until between 7:30 and 8 p.m. on Sundays.
Rough.
Which is against what the court order says. And so do you have anything that you would like the court to know as it relates to that?
Yes, I believe, and I'm understanding in the law that court order is not valid because of the violation of due process of law and my constitutional rights and all of that thing. But Mrs. Karst, almost 3-4 years ago, agreed to the 8 o'clock exchange because throughout the week it's at 8 o'clock. And it was easiest if we just set it at 8 o'clock all the time. And she had no problem. And then all of a sudden, lately, within the last year, she had a problem with it. Or a challenge, excuse me.
All right, so Ms. Karst, I have a question for you as it relates to what Mr. Shores has indicated.
Yes.
Were you going forward with a different time up until this last year or so?
No, I was being forced to go along with that time the entire time. I started showing up at 7.
Objection, clarification to be enforced.
All right.
I do have
Mr. Shores,
text
you
mess-
need to let Ms. Cars finish. Go
But
ahead.
I do have text message evidence when the court order first changed of me texting him and saying, I believe we were supposed to start the 7 o'clock time this week. And he has never released them at 7 o'clock, and after so many times of sitting there for a half an hour to an hour, I started showing up at the time people released them.
objection, Your Honor, I can show you many text messages where Mrs. Karst is sending me text messages just leaving Holly, and it's 8 o'clock at night.
All right.
You're
Mrs. Karst is incredible at making plans, but has challenges following through with them,
You're
All right.
through my experiences,
All right.
Your Honor.
And
Or
so
I'm
we've
sorry.
addressed that issue. I need to move on to the next issue.
Is it all right if we go back to one of the previous numbers? I forgot to
I
say a
have-
couple of things under.
Ma'am,
Which request?
Under the supervised visitation, there were a couple of things that I had written down lower and didn't realize they were for this number.
Are they something different than what's already written in your
Yes.
motion?
but ma'am,
All right.
I
Mr.
have,
Shores.
I have not had a chance, as I've stated, to address these motions before getting here. So I am getting literally blindsided.
Mr. Shores, these motions
By-
have been outstanding since August of 2018. In response to those motions, you have filed over 50 responsive motions. We are here today to address these
So
motions.
you dismiss all of mine, poof, and yet hers are allowed in? How is that being biased or unbiased, ma'am?
Yours were procedural motions. I denied those. We are going on the substantive motions. I did deny one of Ms. Carr's motions in my December order. So
Right,
Ms.
but do you
Carr-
understand, ma'am, that when I am taking all of what I have at time to address the procedures and the previous procedures, because because of my disability, I'm still way back here, and you guys are up here, and I'm trying to catch up. And by that catching up, I'm losing track of things back here. And then this keeps piling up.
Well, this is our time to address these motions, and that's what we are doing. So, Ms. Karst, you had requested an opportunity to make some more comments as it relates to the supervised parenting time. I do think I understand that issue, so I'm gonna, and quite frankly, it is 4:42 and we still have a number of different things to address, so I'm gonna have you go on to the other issues which is the next two issues as it related to telephone contact. You've also asked that it only be, well, I'm not really sure what your request is. As it relates to telephone contact, are you asking that it be monitored by yourself, or are you asking that there not be telephone contact?
I was asking that, really I would like all text messages to be monitored by the parenting time expeditor, if that's something that they do. And that I would like to be able
Objection.
to end a phone
Trespasser
call with
right
Kevin
of-
if it becomes inappropriate with the children.
Violation of Fourth Amendment.
All right, Mr. Shores.
That's an absolute violation of my Fourth Amendment.
Anything else that you want me to consider?
Again, I'm asking for a contingency because I do not have time to appropriately address these motions, and you're not giving me due process.
All right, and Mr. Shores, I understand your position, and I am not going to grant another continuance in this matter. This matter has been continued a number of different times. It's been pending for almost a year. Today is the time to address these motions, and that's what we are.
I object, Your Honor. I have lost 2 hours of assistance from Sanford being here today. So now the entire rest of my week has been messed up, causing me more hardship. Your Honor, I have, can I submit this, Your Honor?
What do you want to submit?
Turn on Do Not Disturb button.
Oh, 1 second. Let
Double
me
tap to make a correction.
find it.
Well, Mr. Shores.
Well, because I have notes, ma'am, and when I'm trying to go through my notes while you guys are talking, I can't find my objections and my law for clarification of this stuff. And so how am I getting due process, ma'am? Do you understand that? Because of the situation, I am ill prepared to be here. I'm here under duress by threats of taking more restraint. And this goes back to the right of habeas corpus.
And Mr. Shores, as I've indicated, we are here today to address the motions. The motions have been pending for almost a year, not over, but almost a year, and so we need to address them today. So as it relates now, Ms. Karst, I believe it's the last motion, you can tell me if, in the parenting time issues relating to fees and costs, and so you're asking that Mr. Shores pay for any court fees and costs. I'm assuming you don't have an attorney, so you don't have attorney's fees in this matter.
You're right.
Go ahead.
I did ask for that before I was granted it's the informa papirs, so I don't need that anymore.
All right, so then I will not address that issue. All right, is there anything in your
Recording.
motions that
2
I
minutes.
missed?
12 seconds. Button.
No.
All right. Then, as it relates to the contempt motion that you have
190308.
filed,
Underscore
Your Honor.
006. By recording. 4 minutes.
Mr. Short.
55 seconds.
This is what I asked to submit.
all right, but I need to know what it is that you want to submit. I can't
One
take a
alert.
recording.
This song is not currently available in your country or region. Okay. Button. 190422. 1 alert. This song is not currently available in your country or region.
Oh, come on.
This song is not currently available in your
Okay,
country or region.
again, I'm asking for a mistrial. I'm not getting due process because my devices, and I have no idea why it is.
And so, Mr. Shores, let me ask you this. For each motion that Ms. Karst has brought, I have asked you for your position on that motion.
I disagree and I deny, and I ask them to be dismissed without prejudice and giving us both time.
All right, and so I understand your position. We are going to move on then to the contempt motion that has been filed. And so, Ms. Karst, as it relates to the motion for contempt, what is left? Because there were some things that I denied.
Yes.
So what is left is as it relates to the payment of child support. Is that correct?
Yes, there are a couple of issues left. Is this the time to enter into evidence
Well-
exhibit A and B? Do you want to do that first? It's the
What we're
first-
gonna do as it relates to the contempt matter is that, because those are not parenting time issues that the court can just kind of consider as arguments of from the parties, you're going to need to provide evidence to the court as it relates to contempt, and Mr. Shores is gonna have to provide any evidence that he has. And so if either of you wish to provide evidence to the court as it relates to the contempt matters, you're gonna need to do so either through testimony or through exhibits. And so if you're going to testify in this matter, then you're gonna need to be placed under oath. And so I'm assuming that that's your position, that you want to testify and provide evidence to the court as it relates to the contempt.
Yes.
All right.
I object.
And so-
I demand a mistrial because I demand a writ of habeas corpus.
And Mr. Shores, that was previously denied, so.
Ma'am, you cannot deny a writ of habeas corpus. You said that we're part of the Minnesota Constitution, correct?
All right, so.
Did you
Mr.
not state that earlier, ma'am?
I did, Mr. Shores.
And what is
Moving
the Seventh Amendment, ma'am?
on. Mr. Shores, we're moving on. So. Ms.
Ma'am,
Karst, if you would like-
objection.
All right, Mr. Shores.
Fraud is a crime, ma'am. Do you understand that?
Mr.
Do you
Shores,
understand that fraud is a crime? And if you perpetuate that crime, then you then can be held accountable. Same with Mrs. Karst. If she is asking for extra parenting time or demanding parenting time, and currently with the parenting time is violating my constitutional rights.
All right, so Mr. Karst, or Mr. Shores, I'm sorry. We've had this issue a couple of times. You don't interrupt the court. If you do continue to do so, you're going to be asked to leave the courtroom. At this
Okay,
point,
then let's
we're
go. Let's
going
go.
forward on our contempt
We're leaving.
action.
This is a kangaroo court.
And Mr.
I object. You're all out of order. And this is just another fine example of how this Constitution is just spat upon.
All right, Mr. Shores,
Let's
you
go.
have the right to proceed if you want to. If you don't want to be here, that's your
Mistrial.
decision.
You are not giving me due process of law, ma'am. Can you explain to me how you are?
All right, and so.
Clarification.
Mr. Shores, we're going to be going forward. on
Corpus
the motion.
non-judice, ma'am.
And so do you want to participate?
Well, I'm gonna pull back and just listen because you guys, this is a kangaroo court. This,
All right, so, Ms. Karst, if you would like to present testimony or evidence to the court, you need to be sworn, so you need to stand and raise your
no,
right
I'll
hand.
sit right here.
You do swear that the testimony you provide during this hearing will be true and accurate to the best of your ability, so help you God.
All right, you can have a seat. Ms. Karst,
Objection. Can she clarify God?
she's just been given an oath. So, so we're going to proceed now. So, Ms. Karst. as it
Objection.
relates to your
Contempt of
motion
court.
For contempt of court, you may.
Mrs. Karst in contempt of court.
Mr. Shores, you need to stop interrupting the court. Ms. Karst, you may proceed with any testimony or exhibits that you wish the court to receive.
Okay. I'd like to enter in exhibit, excuse me, exhibit P, which is the affidavit of arrears.
All right, so you have an exhibit, you've indicated it's an exhibit P,
Yes,
and you've indicated that that is an affidavit of arrears.
yes.
And before I
Objection.
receive it, I just need to kind of know some information about what it is. So,
Objection. I don't have such a thing.
all right. And so
And
that's what I'm trying to find. I don't have it either, Mr. Shores. That's what I'm trying to figure out what it is. So when you say it's an affidavit of arrears, who is it by?
It is done by the Clay County intervener.
All right, so, and does it outline the amount of money that is being owed in this matter?
Yes.
All right.
objection. You said owed. Can you show me a debt? A debt where I have ink to paper.
All right, Mr. Shores,
Is this a Title 4D?
it is, well, it was. So this
We're
is,
talking about child support now, right?
this is from the order from October 18th of 2012. So as it relates, Ms. Karst, you've indicated there's an exhibit, it's an affidavit of arrears, and you're asking to, you're offering that as an exhibit.
Yes.
All right. Does that outline the amounts that have been paid and the amounts that are due and owing?
Yes.
And is it
Objection.
accurate?
Yes.
Objection.
Is-
I cannot witness this, so I demand it not be allowed as evidence.
I do have a copy for Mr. Shores.
And she has not given me due process of law.
All right. And so you can provide a copy to Mr. Shores.
And that's a violation of my law. That's a violation of the ADA, mistrial.
All right. And so you can also give that to the deputy.
I demand a mistrial.
I can only have one person talking at a time.
Sorry, ma'am.
If Mr. Shores would like to observe a digital copy of this, I could pull up my email that has it on there that I served to him by.
Did you previously send a copy of this to Mr. Shores?
Yes.
And what was the
Via
date
email.
of that?
Let me find it, I'm sorry. Your Honor, I don't have a list of the dates that I served my exhibits, but I believe this was the one in the last things that I served on April 15th or 16th.
All right.
And then I was told by the Clay County Child Support that there was a copy of this served into the court file already.
Let me go back. Because there was an affidavit of arrears that was filed in this matter. However, I don't know if that was ever sent to Mr. Shores. It might have been put in the court file, but I don't show anything that shows that it was sent to Mr. Shores. And so,
I did have an affidavit of service for this.
you do?
Well, I submitted one into the court file for Exhibit P. I should have.
is when you sent it just on April 15th?
I believe that was the date, yes. In the affidavit I sent after that. Or I filed after that.
All right. I do have an affidavit of service by email that shows that that was served by email to Mr. Shores, the Exhibit P. But this says that must be related to the parenting time, because what is listed as Exhibit P on your affidavit of service is a text thread.
I had made one clerical error. I served something to Mr. Shores that should have been labeled as R, and I labeled it as P. And so when I was looking through, I originally thought I didn't have that in. But in the body of the email, it actually was Exhibit P. So I'm not entirely sure if it got filed with the court that way too.
All right, well, for purposes of this hearing, I will receive it. However, I'm going to...
Objection.
I'm going to read it so that, because I haven't seen it, I'm going to read it. So
I can't find it either, ma'am.
So that Mr. Shores can actually know what's on it.
And I do have a digital copy with me on my laptop if you need for Mr. Shores too.
All right.
Objection again, bias. Bias by the court, vacating your position.
All right, and so you've indicated Exhibit P. We need to put our own exhibit sticker on it. I'm going to identify this as Exhibit 1 for purposes of the contempt hearing. And I will note that it is what is listed as an affidavit of arrears in this matter. It is an affidavit which goes through starting with year 2011, all the way each year through 2019. And it indicates, there are different columns indicating for each month an amount that is due, as well as any interest, an amount that has been paid, a balance due. There's a balance due Minnesota and a total balance due. And I will note that...
Objection, Your Honor, that any deprivity of any benefits or life, liberty, or property from me above $20 is allowed a trial by peers. Writ of Habeas Corpus.
And Mr. Shores, I've already denied your request for a jury trial. This is not a matter that is subject to a jury trial.
There's no, where is the jurisdiction? The proof of the burden is for her to show injury in fact.
All right, and I'm fairly certain that that's what Ms. Karst is attempting.
Where's the injury?
All right, so I am indicating, Mr. Shores, so that you are aware of what this exhibit is. It shows that as of February of 2019, the child support that is due is $1,073. The amount due to Minnesota is $193.
Objection, Your Honor.
Mr. Shores, I'm just trying to read the exhibit to you. The interest due to child support is $98.28. The interest due, custodial parent, excuse me. The interest due to Minnesota is $5.34. The amount that you paid was $507.70. And it goes back each and every month before that, showing that there was a payment made by you of $507.70
Objection.
in January.
No, that's not true.
There was a December payment of $498.60. That continued. There was no payment in September of 2018. There was a payment in August of $997.20. Prior to that, for the months of July of 2018, going back all the way to January of 2015, payments were received each month of $460.20. In the year 2014, there were payments of $451.80 each month, except for August where there was a $9,338 payment and 11-cent payment. In 2014.
What was that date, ma'am?
August of 2014.
Ma'am, may I clarify about that payment?
You can after I get through the exhibit. In 2000, well, I shouldn't say that. When it's your opportunity to present
But
testimony, you
ma'am,
can.
I'm not getting due process because how am I able to make notes on? See, this isn't due process. If you're expecting or accepting this evidence, I am not having the opportunity to utilize it in a best manner afforded to me. Because I need time to take notes, to examine it, to prepare, to rebuke it. And how am I afforded those rights if you're just accepting it now?
You will have the opportunity to tell
When?
me what payments you have received after I've heard from Ms. Karst.
But and not of sufficient adequate time to give me due process of law, ma'am.
All right. So I've indicated as I'm reading through this document, Mr. Shores, so that you understand what is in it. In 2013, it's indicating that you made payments of $444 each and every month, except for the month of June, where you made a payment of $1,139, and in September, when you made a payment of $8,266.34. And that then there were payments made in 2012 of $438.60 each and every month, except for the month of February, where a $600 payment was made. This indicates that the total amount that is due at this point for arrears is $37,613.19. All right, so Ms. Karst, what other information do you want the court to receive?
I object, Your Honor.
What is your objection, Mr. Shores?
Again, you are talking about child support, a Title 4D, which is the state of Minnesota, Holmberg's versus Holmberg, declared child support is unconstitutional.
And I have addressed your motions, Mr. Shores,
And
I have noted your objections, and that is
And to-
overruled, and Ms. Karst, you may continue.
you're,
I'd like to offer Exhibit C, that my sworn affidavit, into the record.
All right, instead of, and for purposes of this is just like a trial, and so you need to provide the information to me.
excuse
by
me, did
testimony.
you say this is a trial?
That is correct, Mr. Well, it's an evidentiary hearing, it's the same thing as a trial. So-
Objection.
All right, so, Ms.
Again,
Mr.
Your
Shores.
Honor.
We need to proceed. I understand that you've indicated an objection. I understand that you believe that you have a right to a jury trial. That has been denied multiple times, and we are proceeding.
Your Honor,
Miss-
I would like to submit as evidence the Constitution of the state of Minnesota.
You will have an opportunity when it's your turn to present evidence to the court. It's Ms. Karst's turn, so Ms. Karst, you may proceed with your testimony as it relates to the child support contempt issue.
Am I allowed to cross-examine her?
You will be once we get to that point. So, Ms. Karst.
Okay, if I may enter into evidence Exhibit A and B, although I don't know if I need to since these were filed already. They are the divorce decree and the appeals.
Those are already part of the court file.
So I don't need to enter those in. Okay. Kevin has only paid the minimal amount of child support that the child support office is allowed to obtain out of the social
Objection.
security check up until.
Ms. Karst, just wait. What's your objection?
Where is a signed agreement of debt? She keeps making these,
None is needed.
she's interrupting me, ma'am.
Ms. Karst, you need to wait for Mr. Shores. Mr.
That-
Shores, I will tell you that all
You're
of this,
interrupting me too.
I understand, I'm trying to clarify for you, Mr. Shores, that all of this arises out of the October 18th, 2012 order, where child support was ordered. So that's where we come from.
But there is not a debt on record.
And that was
Can
the
you
prior.
evidence, I need the evidence that there is a debt that I contracted because you're saying I made these payments. I have not willfully made I have not willfully made any payments whatsoever. They have been stolen from my Social Security disability and now my veterans disability benefits, not income, benefits.
And I understand that that is your position, and your motions to that effect were previously denied as it related to a written contract. And so Ms. Karst has the opportunity to proceed. So Ms. Karst, you may do so. What you stopped with was the fact that there was minimal amounts that have been received by you.
Yes, and that has ranged over the years from $438 to $570 per month for both girls together. The court awarded the child support amount of $1,000 plus $193 of medical obligation to be paid by Kevin for child support after hearing testimony from myself and seeing and reviewing financial documents of the assets of both myself and Kevin Shores. Kevin brought the matter to the Court of Appeals, as has been noted here several times, arguing that because of his ongoing medical expenses, he should have a downward deviation in child support. The Court of Appeals stated in paragraph 2 on page 8 of their decision, which I have entered into evidence, the following. Appellant Kevin Shores' argument is without merit. The district court found that respondent Laura's income earning ability was reduced by her role as appellate's caregiver. The court also found that under the child support guidelines, appellate's presumptively appropriate support
Objection.
obligation of $849 is, quote, insufficient to meet the children's needs.
All right, just wait 1 second. What's your objection, Mr. Shores?
This is irrelevant. You're letting her go back to the previous court, yet I'm not allowed to address the previous court? How is that
That is
being unbiased, ma'am?
overruled. You may continue, Ms. Karst.
Thus, the court determined that an upward deviation was appropriate, noting that the main purpose of a deviation from child support guidelines is to prevent either parent or the joint children from living in poverty. In making its decision, the district court specifically found that appellant has a gross monthly income of at least $4,000.
Objection.
And that deviation of an
It is not an income.
All right.
It is benefits.
All right, that is duly noted. You may continue, Ms. Karst.
Of an additional $151 per month is not beyond his means, nor does it prevent him from meeting his own needs, given his substantial assets.
Objection. How does the Court of Appeal know my needs?
All right. Mr. Shores, if you're going to make an objection, it needs to be as to the form, either you made an objection as to relevance and those type of things, but as it relates to this, Ms. Karst, you may continue.
The district court's findings are supported by the record. Therefore, the district court did not abuse its discretion by ordering the upward deviation from child support guidelines. The appellate court further noted the following on page 6 of their decision. The court also
All right,
found...
and Ms. Carson, I'm going to stop you just because of the time that we're sitting at this point. I have the Court of Appeals decision. I have the district court decision. Those are both orders that this court needs to review as it relates to, because they're the orders that is in existence at this point.
Objection,
And so
they
you
are
don't
both
need to read
void.
from the orders. So, Ms. Carson.
During the last 7 years, my children and I have faced extreme financial hardship. I struggled to provide for my children while Kevin did not pay any of the asset division he was ordered to pay me, did not help me with any of my housing costs, paid no child support until he was ordered, and after that still pays only a quarter of what he was ordered to pay. It began with nothing. I had no college degree.
Objection.
I had college debt and
Wait,
no
Ms.
degree.
Carson, what is your objection, Mr. Shores?
I paid with my disability for Mrs. Karst
All right.
to complete yoga instructor's training.
All right, Mr. Shores.
She has not had a job in the last how many years?
Mr. Shores, that's not an objection, that's you testifying. And so you need to either state a legal objection to something.
Objection, irrelevant.
All right, that is overruled. Ms. Carson, you can continue.
I had college debt and no degree and no savings. With the help of my mother, I was able to live in an apartment with our daughters and obtain a vehicle, as Kevin would not let me use the family vehicle, and I had been relying on walking and using a wagon for getting home after shopping with our daughters. I've had to rely on food support, energy support.
Objection,
and
hearsay.
the food shelf, and we worry about the cost.
Objection,
There's no
hearsay.
objection. That's overruled, Ms. Carson, you can continue.
We worry about the cost of gas to bring the girls into town to go to school. I'm not able to afford to buy new clothing for the girls. I shop entirely from secondhand stores and garage sales. I'm unable to provide any extra little thing the girls ask for. Every extra purchase is a financial strain.
All right, and Ms. Karsten, I understand what your testimony is. I'm going to just, so that both of you are aware, for purposes of the contempt action, the court needs to consider, first of all, whether or not there is an obligation out there. There is a court order out there. Whether or not Mr. Shores has paid on that obligation, and then whether or not he has the ability to pay that child support obligation. Those are the issues for the court to determine. And so those are the issues you need to address for me. So in order to determine whether or not he's in contempt, I need to determine whether or not he has paid his child support, what amounts he has paid, what amounts are still outstanding, and whether or not his financial circumstances have changed in any way since the original judgment decree so that he is not able to pay them. And so, as it relates to those issues, is there anything else that you want the court to consider?
One moment, I just want to go through my notes. I do want to make a note that I did apply for an apportionment through the VA to obtain the remaining amount every month of the child support that Kevin refused to pay. And they did grant that this month. So March 26th, and I would like to enter that into evidence now if I can. I got a letter from the VA stating that the apportionment was granted and also...
Objection.
Wait, Mr. Shores, what's your objection?
It's irrelevant, and it is still standing on the decision of what is going on. As I stated earlier, because of Sanford refusal of opening up my mail since December, I was not adequately informed about what was occurring with my benefits, and so I have not had any recourse of them. I was only made aware of them 2 weekends ago when I was able to hire somebody for 4 hours to help me through my mail. My mother came up this weekend on Saturday and spent 5 hours going through my mail and trying to help me address it.
All right, and so I understand that what your position is whether or not that is going to stay is the issue, and I understand that, but that's not a basis to not allow the information in. So Ms. Clark, that's overruled. Ms. Karsten, you may continue. So you had indicated on March 26th, something on March 26th, 2019.
March 26, 2019 was the letter where the apportionment was granted, and it tells the amount monthly.
And what is that amount?
$814.
And so you will be receiving that?
Yes,
Right.
they will be making up the remainder of $1,000, so I will be receiving $1,000 now.
Beginning when?
It was the beginning of this month I received the first check, or first 2 checks, one for each girl. I also, that I had as Exhibit O.
And so you've just testified to the information, and so is there any other information in there that is not something that you've testified to?
I don't believe so. No.
All right.
And then if I could, I also had Exhibit N, which was a letter from the VA dated January 10th, where they were asking me for more information because I had applied for the apportionment, but I hadn't. Apparently, they wanted some more information from me, and we had court following the time when I got this letter. And on the record, you had indicated that Kevin was saying they were already taking VA apportionment payments, and that was not happening. So I just wanted to enter this in, showing the date of this, requesting more information.
The letter that you received dated March 26, 2019,
Yes.
you want the court to receive that letter into evidence?
Yes.
All right, and so you can give that to the bailiff.
Objection again. This court has not given me due process. As I've stated, I have not had any adequate time to come here and prepare any evidence for this hearing.
All right, and so I understand your objection, Mr. Shores. What I'm going to do is I'm going to read this to you so that you know the body of the letter. It is dated March 26, 2019. It is to Infinity as, is it, how do you pronounce it? Spheria Shores, in care of Laura Karst. Dear Ms. Karst, we have carefully considered your claim for an apportionment of the veterans' benefits. This letter will explain our decision and what to do if you don't agree with it, as well as what you should do if your status changes. What we decided: after reviewing all evidence submitted by you, we have awarded the following benefits for Spheria Shores and Infinity Shores. Monthly rate, $814. Effective date, June 1st, 2018. Reason for change, apportionment granted. Then there's another column that says the monthly rate $407. Effective date, July 25, 2021. Spheria turns 18 and apportionment is terminated. And then the final column is 0, October 10th, 2025. Reason for change, Infinity turns 18 and apportionment is terminated.
And there is, Your Honor, a small clerical error.
That's
because
major
Infinity's
clerical
birthday was
errors.
July
One
25th.
person at a time, please.
It is Infinity's birthday, that's July 25th, and Spheria's, that's October 10th. I have not notified the VA of that yet.
But I just wanted to read what the letter said. Then it goes on and indicates, which I think that's because then there's some other information about how they made their decisions and how to send other correspondence. And that's not part of what they've actually apportioned. And so I will receive that first page of the letter. I'm not going to receive the rest of it because it doesn't have anything to do with what they're actually apportioning. So, we're going to mark that as Exhibit 2 for purposes of this hearing with those amounts. All right.
Objection, how,
Mr. Short, wait. Mr. Shores, what's your objection?
objection, how does this evidence show a injury in fact? How are you, where's the evidence showing that I am not supporting my children?
All right, and so Mr. Shores, this exhibit has been received to show the amounts of money that the Veterans Administration is now going to be paying as an ongoing amount for the child support.
Your Honor,
Mr. Shores.
this is my VA benefits.
And
Can you let me finish, please?
Sure.
You're asking. See, again, you're being biased. You interrupt me, but I can't interrupt you.
Mr. Shores, I simply wanted to clarify that I have nothing to do with the VA benefits that are or not being taken out.
But I would like you to understand, and this is again where I am demanding an objection, because you do not have any authority to make judgments on my daughter's life. This is why I demand a trial by peers. So there is not one individual making such a judge. This is a monumental judgment of my daughter's. And by giving you in the position where you keep vacating your position, by practicing law from the bench, by being dismissive to me, by not giving me due process of law, my benefits are calculated by the federal government. And in those entirety of the benefits, if I have dependents, I am awarded a compensation of a certain value. The federal government has declared that value, not only in my benefits by the VA as a 100% disabled veteran, but as the...
Mr. Shores, Ms. Karst is now objecting. I have stopped Ms. Karst every time that you have made an objection. Well, I'm going to stop you because I understand what your position is, but again, you're providing me with evidence or information you want the court to consider on an objection. And so you need to state the legal basis for your objection, and then Ms. Karst is gonna finish. So what is the legal basis for your objection?
It doesn't matter. This is a kangaroo court.
All right, Ms. Karst, you may continue.
Oh, it does matter,
I was asking
though.
if I should offer Exhibit 2 to Mr. Shores to review.
Is that the letter? All right, you can give, because the court's only receiving page 1, that is what's been received by the court.
Objection. Again, violation of my Americans Disability Act rights.
And Mr. Shores.
You're giving me paper.
I do have digital copies of everything.
And
so-
Mr. Shores, that's why I read that letter to you.
But that
so
still is not getting me due process of law.
I understand what your position is, and Ms. Karst, I will ask that after this hearing, that you also provide digital copies to Mr. Shores of all of the exhibits so that he has them in his file.
Your Honor, I have provided digital copies of everything. I've served everything via email. He has everything digitally.
And the only reason I say that is because that affidavit of service is not exactly correct. It refers to different exhibits that are, I mean, like I indicated, Exhibit P on your affidavit of service is not in fact what Exhibit P was. And so I want to make sure
Exactly.
that
Oh my God.
Mr. Shores.
I'm sorry. Please forgive me for my frustration, ma'am. But from my point of view,
I'm having
I'm
a
being
hard time
violated.
listening to the instructions of the judge.
All right, both of you need to stop, and we need to do one at a time. So, Ms. Karst, so that I know that Mr. Shores has digital copies of each thing that the court received as an exhibit, I will simply ask that you provide him with a digital copy so far of the 2 exhibits that the court has received that I have read into the record.
To the appropriate
After the
email,
Need to
please.
label them
One.
as the-
Exhibits 1 and Exhibit 2. All right? All right, now,
To the,
any other information, Ms. Karst?
Not in this specific letter. We were on, I believe, C, right? Okay, I think
I
that's all
received the letter of March 26, 2019.
Okay. So following down the contempt order was D, which we already dealt with, was the 7 o'clock parenting time. That was something we already talked about on the last order. But it was something that came up on this one too. E was that all parenting time was supposed to be conditioned on the presence of one caretaker with Kevin, and on him identifying to me the name, address, phone number, and having a verification that a background check was done, and that they have a valid driver's license and a picture identification. I've noticed many times where, well, first of all, he's never ever provided me with a background check.
Objection.
Anyone who's worked with our children. or
Not
cared for our
true.
children.
Mr. Karst, what's your objection?
Mr. Shores.
Or Mr. Shores, I apologize and continuing to apologize, but about Miss,
Not true. Hearsay. There.
I've never received a
all right,
background.
Ms. Karst, I need to rule on the objection. So your objection is hearsay, and that is overruled, so Ms. Karst, you may continue.
Mr. Shores has many times suddenly had a person living with him that he's never introduced to me and I don't know the name of, and I'm expected to allow my daughters to live with this person, and I've never seen a background check on any of those people.
All right.
Now it seems that there is no caretaker present at the home anymore. For several years it seemed like a tapering off of caretakers as he had been ordered to have them. But now, for the last couple of years, it seems like there is nobody there ever when he has the girls. And I believe that
Objection.
it's becoming an issue.
All right, so now, I just want to clarify, we are on to, not the child support contempt, but some of the other things that were in your contempt motion.
Yes.
All right, and so I need to take a break. It is right now 5:24, and so we're gonna just take a quick break, and we're gonna come back in and we're gonna finish the other issues.
Your Honor, I was informed earlier that we would not be proceeding past 4:30.
All right, well.
And I have a regimen because of my health, which I am an hour off of, as you heard my alarm go off earlier.
And I understand that, but we need to finish this matter, and so we're going to finish this matter.
But
We're gonna
ma'am-
take a break,
oh,
break
my-
at this point, and we'll be back in about 5 minutes.
Douglas, in that backpack, there's photos of wounds. There's a package that says photos. It's in a blue folder, I think.
There's no folder.
What?
No folder in your backpack.
No, the briefcase bag. Sorry.
That one's down there.
Where?
Down in the van.
Oh,
Nobody's
dude,
in here right now. You want me to run down there?
this is bullshit.
Well, here's the thing. There's a couple violations going on, I see it, but you can't address them. You can argue with the judge all day long, but some of the things it seems like she's kind of pushing off to the higher level court anyways. Like she doesn't want to deal with them. Like she's just going for it. She's saying noted. Okay, noted. Overruled.
Right.
So it's kind of like she's
She's
making
just trying
you
to
do the work
It's
of,
called abandoning ship,
yeah, I see that.
is what they call it. She's
Well, you're
abandoning
kinda-
ship.
You're not making it easy on her.
Yeah.
Shit, man. Jesus.
Yeah, she's abandoning ship because she's in total violation of the law, and I hope they're listening. And I hope her soul isn't as black as her robe. Are the bailiffs in here?
No, they're I mean, but she's being very patient from where I'm standing.
Oh, yeah?
And a couple of things, like, I know she doesn't know, and you'll have to address those on a higher court, but I can tell she's being patient, though. She's trying to be patient. She's trying to address the different things. I hope she's not playing favoritism, you know.
She is.
Laura's got about 25 folders over here and a laptop.
She's in such a financial strife, but she has a laptop.
You want your microphone off?
Yeah. Did you like that point I made about the microphone?
Yeah, I can see she's trying to be fair. Some of the things you have to point out more, but if you can take a step back and try not to point them out with your emotions as much as your mind.
Mm-hmm.
You know what I mean? Because the emotions part, even from a standpoint, like I can't see the parts coming up where you guys are both getting kind of fired up. I can tell afterwards by your responses. But, so I mean, try to not get flared up so much, but still make your point. Like, don't have the emotion in it as much. You have to, I know, to a certain point, but you gotta be able to communicate. Would you like me to go and get that
What?
out of your briefcase, that blue
Yeah.
folder? Huh?
Yeah.
Do you want the whole briefcase?
Yeah.
Okay. I'll be right back. Keys.
Laura Karst and Kevin Shores matter. And so we were addressing Ms. Karst's motion for contempt, and we got off of the child support issues. So I want to just ask Ms. Karst before you go into what really is probably part of the parenting time issues in here, but as it relates to the child support contempt, is there any other information or evidence that you want the court to consider as it relates to that issue?
No.
All right, so I have a question for you as it relates to this apportionment that you've talked about. Does that just cover ongoing support?
Yes.
All right, so that doesn't cover any of the arrears that, or any of the money that hadn't been paid?
They gave me payments from June. I think it's indicated in that. They gave me back payments from June forward.
All right.
But prior to that, June, then there were no other back payments.
All right. All right. Then the rest of your motion addresses, the only thing that I think that is in the contempt motion that we haven't addressed is the issue with, and it really, again, is not a contempt issue, it's a parenting time issue, is as it relates to the issue you were getting into, which is whether or not a caretaker is present and whether or not you've been provided a background check as was required in that October 2012 order.
Yes.
All right. And so you have provided me with information that basically you have not gotten that and that the caretaking has kind of gone downhill or been non-existent.
Right.
All right. Anything else that you want me to know about that issue?
I think that one thing I do want to mention also about him not having a caretaker in the home is that though it's fine for Infinity and Siri to help him, I don't want them to become his caretakers because it's not fair, especially for my 15-year-old daughter to be Kevin's caretaker and the babysitter for her 11-year-old sister, and also try to maintain a normal teenage life.
Objection.
What is your objection, Mr. Shores?
Where's the evidence of wrongdoing and injury of fact?
All right, and so Mr. Shores, that's overruled, that's what she's provided me as testimony in this matter, so.
Kevin has significant caretaking needs and he's severely limited in his ability to manage the tasks of maintaining a home and caring for the basic day-to-day needs of the children, so I believe him not having a caretaker for the girls is a significant issue. As far as ongoing with Sphera, I feel the same way. As once she gets to be older and Infinity moves out of the house, it's not fair for her to become Kevin's caretaker as he's not providing caretakers for them. And there's no one to provide transportation for them then because he's not having the caretaker who has the valid driver's license, and now as they've become involved both in activities this year on his parenting nights, it's become an issue, an ongoing issue of how they're going to get a ride home. Where if he had the caretaker who had the driver's license as he was supposed to, they would have the ride they need.
Objection.
What is your objection, Mr. Shores?
She's lying. Where's the proof of these words that she's saying?
I do have.
All right, and so,
entered
wait,
into
Ms.
exhibits.
Karst, I need to rule on his objection. I understand that you disagree with what Ms. Karst has said. That's not a legal objection. You will have an opportunity to testify as
Hearsay.
well.
It's still hearsay.
And she's providing the information. It's not hearsay that is overruled. Ms. Karst, you can continue.
I would like to see background checks on any individual who cares for or spends a significant amount of time in the home with Infinity and Sphera. And I would like a caretaker in the home when Infinity and Sphera are there with a valid driver's license, and that was something that was ordered prior. And I also need a clear and enforceable plan for when he does not have someone there because the police don't help me with that. And I need to know where to go for help when this is occurring.
All right.
Your Honor,
Mr. Shores.
or excuse me, I mean, there's part of me that wants to give you that title, but the disrespect that I feel you're giving me, I'm trying not to get into my emotions here.
All right, so Mr.
But
Shores.
our children are 11 years old and 15 years old. My daughters ask for monetary gain. out of that monetary gain, if they fulfill their chores and their duties, they have all, sorry, me and my kids, we laugh when we hear the word duty. And
Mr. Shores, again, you're
But-
providing, Mr. Shores, I want to stop you because you're providing information to me, which you can get into, but we need to do this in the proper order. And so at this point, Ms. Karst has provided me with her testimony and evidence as it relates to the child support contempt and this additional parenting time issue. And so, do you have any questions for Ms. Karst on the issue of child support contempt? Questions as to the information she has provided to the court?
yes. My question is, when is the last time that you worked?
All right.
When is the last time you've had a job?
And Mr. Shores, excuse me, as I've indicated previously, the issues for the court to decide are whether or not there is a child support order out there, whether or not you have paid consistent with that order, and whether or not...
Objection! Clarification in the definition of paid. Show me a debt. Show me a contract that I signed.
Mr. Shores, I'm telling you what the issues for the court to decide are, which
You're
is,
abandoning ship.
one is whether or not you have an order, number two, whether or not that's been paid, and number three, what is due and owing, and number four is whether or not you have the ability to pay. And so whether or not Ms. Karst is working does not address those issues.
Well then,
And so you need to ask a different question.
okay, well then I therefore make a motion that Mrs. Karst is in contempt because this order told her to take her name off the home. And
so-
she has not to this day.
All right, and so you have not brought a motion for her contempt,
I just did.
and so that has to be in writing and provided to the court at
Again,
14 days prior.
Denying of due process
14
because I do
days.
not have the assistance to do such things.
Well, we're not considering that today, and so, Mr. Shores, do you have any further issue or questions as it relates to the issues that I've identified with regard to child support contempt?
Clarify the last one.
Do you have any questions of Ms. Karst related to the information she provided to the court on the child support contempt issue?
Again, I'm saying no due process because I don't have it right in front of me to go over. I haven't had adequate time to have it ready. So again, I deny and I object to all of her motions that they should be dismissed.
And I understand, Mr. Shores, what your motions are. You've raised them now a number of different times. As I've indicated in all my prior rulings of the court, this matter has been pending for almost a year, that there have been multiple hearings in this matter, and so we need to proceed at this time, and so your motion is denied. Do you have any questions for Ms. Karst?
Yes, my question is, after all of these years, why now is this being the issue and the case? She has a new 2-year-old child, no job. Her husband, my ex-best friend,
All right,
doesn't have a full-time job.
Mr. Shores, that's not a question. The question
But
was why
how,
is this
okay,
motion
how
denied?
much money are you getting from me right now? That's a
That is
question
that is a question, Ms. Karst.
on my behalf,
As
excuse
of
me.
This month, I will now be getting the full $1,000 a month of child support, or did this month. Kevin also gave me $100 this month. It's not typical.
And how often do I give you cash?
Probably twice to 3 times a year, I would get about $100 to maybe probably $100 to $150 or somewhere in there, which is supposed to cover the cost of
Your
clothes, which
Honor?
doesn't cost.
When-
I need-
part of the cost of the clothes.
Mr. Shores, I need you to stop. Ms. Karst, you were finishing your answer. I want to clarify so I got the information down correctly. Did you indicate that 2 to 3 times a year?
Yes, that he
You were-
may give me, actually he passes to the girls about $100 or maybe 120 or 160, something like that, and it's supposed to be towards their clothes, which I do use towards their clothes, but I just am making a note that it's only about a quarter of what I'm going to need to spend on their clothes, and it's
Alright.
not even a drop in the bucket towards what he owes in his child support.
All right, so Mr. Shores, any other questions? Mr. Shores, do you have any further questions?
Your Honor,
Yes.
you're denying me due process. I need to go on my device and open up some things and find some things. And I mean,
All right, and if you need some additional time, you just did not said anything. I didn't know if you were done with your questions or if you had
no,
additional
well,
questions.
this is the challenge, ma'am. This is a challenge. As I have stated, I have not been given adequate time, so I have like the bare bones of stuff on my phone.
Objection.
And-
All right. Ms. Karst, we need to deal with if Mr. Shores has any questions. And so if Mr. Shores has any questions, he has the ability to ask those questions at this time. And Mr. Shores, I understand that you've indicated that you don't have all of the things with you, but obviously today was the day for a contested hearing. And so you were expected to come forward prepared. Ms. Karst is prepared to
Ma'am.
come forward, and so Mr. Shores, you may.
Ma'am, do you see before you a blind, disabled man with limited dexterity?
And I
Can you even fathom or imagine how long it takes me to do something in comparative for you to do something? Throughout the week, the VA has authorized 120 hours a month to assist me in my daily living activities. I am lucky if I get 50, maybe 60 a month. I have not been able to afford assistance full time. I was paying up to 90 hours a week in people coming and helping me achieve these goals since 2014. Since 2014, ma'am, I have not slept in my bed.
All right.
I have slept in my chair.
Mr. Shores, we are going to continue with this hearing.
The
so
money that is given to me from my benefits
Mr.
are...
Shores, I need to stop you because we are at the point where I need to know whether or not you have any further questions for Ms. Karst.
Yes, I do, but I am not able to attain them for lack of due process and violation of my ADA rights.
So you are here, and so what questions do you have of Ms. Karst based on her testimony?
Well, how do I object, ma'am, when they are lies?
All right, well, you're going to have an opportunity to also
But,
testify
ma'am,
in this matter.
Ma'am, are you not supposed to help me? Since
I
I am
don't-
representing myself, aren't you supposed to help me unbiasedly through the procedures of this? So my question to you again is, how do I object to Ms. Karst when she is lying?
All right, and as I've indicated, Mr. Shores, you have the right to testify as well and provide the court with information, and we're going to get to that. And so you've made multiple objections in this matter, and so Mr. Shores, my question for you as we are in this procedure is if you have any further questions for Ms. Karst. If you don't, then I will turn to you, and if you want to present testimony and exhibits to the court, you can be placed under oath, and you can also provide testimony to this court. So do you have any further questions for Ms. Karst?
Yes, I do, but as I have stated, I am unable to access this at this time, and this court is not allowing me appropriate due process to do such a thing.
So can you please indicate to me what is on your device that you need to access?
May I show you, ma'am?
No, I need you to
Okay,
articulate to me
so
what is on your device that you
I
can't.
have emails and notes that have laws and how to cite those laws to bring up the fact that child support is not legal. It is unconstitutional.
All right, and Mr. Shores,
You-
it's not a question to Ms. Karst. That is a legal
You
argument.
just, ma'am, you just asked me to clarify, and now you're dismissing it.
And if you let me finish, I was going to indicate you've already brought those motions before the court, and the court has already denied those motions. And so, for purposes of this hearing, the issues for the court, as I've indicated, are whether or not you have a child support obligation, what that obligation is, whether or not you've paid that obligation.
But the obligation is unconstitutional, ma'am.
And I know that you've made that argument and that's been denied, so you need to move on, Mr. Shores. And so, Mr. Shores,
Okay, well, I'm just going to rely on my paperwork, and I'm glad you have insurance because I will be holding you in contempt and violation of my rights.
all right, so.
And everyone else in this courtroom,
I will take
including the
that.
bailiffs and Mrs. Karst.
All right, I will take that, Mr. Shores, that you have no further questions for Ms. Karst.
No, that's not true. I do, ma'am. But I said you are not allowing me adequate to get them. So dismiss me again as you have continuously.
So, Mr. Shores, at this time, do you wish to present any testimony to the court?
I am not prepared, ma'am. As I have told you, I am here under duress. I do not waive any rights whatsoever unless it is ink to paper.
All right, and so, but that didn't answer my question. My question is whether or not you intend to testify as it relates to the child support contempt issue.
Not at this time.
All right, do you intend to offer any other evidence into the record?
Yes.
And when I say evidence, I mean anything as it relates to the issues that I've identified, which are whether or not there is a child support obligation, what that is, and whether or not you've paid it and what your financial situation is.
Well, as I've stated before, some of the evidence I have already submitted to you. I asked Crystal Nelson to give them to you because I sent letters to the child support agency and they did not respond to them, therefore stating the questions as true.
All right, and I understand, and those
That-
were part of, I will just note, Mr. Shores, those were part of the court file, but
But I want them to be added as evidence now, ma'am.
But they were requests to the child support office, and whether or not you've made requests to the child support office is not an issue for this court.
But the letters themselves I want to submit as evidence.
What letters?
The letters that were sent to child support to ask them to show me where the debt is, where the administrative agents
Objection.
All right,
That's
and
not needed.
Ms. Karst, you made an objection. What is your objection?
That there is not a legal basis for him to have to say that those aren't legal papers and to have a trial by jury as he's requesting.
Right.
Doesn't have a legal right to that in this instance.
And so, Mr. Shores, you've made some requests for basically to view what the legal debt is, and as I've indicated a number of times, the legal obligation you have is pursuant to the court's October 2012 order. And so, do you have any other evidence that the court needs to consider, or do you want to testify?
Again, my hands are tied.
All right, and so there was one final issue that Ms. Karst had brought up as it relates to the it was in her child support contempt motion, but it's really related to parenting time. And you've already addressed this in some regard, Mr. Shores, as it relates to having a caretaker present and having them provide background checks to Ms. Karst pursuant to the prior order of October of 2012. And so I know that you've indicated what the children's ages are, and that they are your utmost responsibility.
But-
And so is there anything else you want me to know as it relates to that issue?
Yes, as far as the whole parenting time and all of that?
Well, the issue before the court is whether or not the court should take any action with regard to the prior order that you have to provide verification that there are caretakers present and that they provide background checks.
Your Honor, as I have informed Mrs. Karst about that, I said, I have collected all said information and she has access to it, but I fear it is a violation of their rights, and if it is not needed at the moment, because there is no challenges that arise, that they are there in my records.
All right, so you
And-
I just want to clarify so I understand what your position is. You've indicated to Ms. Karst that you have those records, but you don't think that it's appropriate to share them with her because you believe that that's a violation of the individual's rights, but that you do have them in your paperwork.
Yes, this is true up to 2014. After 2014, the only way that I am able to compensate or assist someone in helping me beyond my daily living activities that Sanford cannot fulfill, I have offered very dear and close friends to reside in my basement under agreements of them assisting me with home task, chores, and the such. Unfortunately, they have not always worked well because of my situation of being blind. People take advantage of me and do not fulfill the obligations that were discussed. And therefore, I will ask people to leave. But again, I have stated, at 11 years old, Mrs. Karst was babysitting. At 11 years old, I was babysitting. Our daughters are extremely intelligent children. And the fact that Mrs. Karst believes that they need supervision, I find insulting to not only me, but to my daughters.
All right. Anything else as it relates to that issue?
But again, I'd like to bring up in the fact of the daughters with the alleged caretaking assistant, they have been made aware that if they would like to have extra money, then we will set up chores, and some of them do have to be involved with helping with my activities of setting things up or making sure the washer is switched with the dryer or folding clothes or sweeping the floor. Just regular household activities that Mrs. Karst has not shown them appropriately how to do.
All right, I think that that has addressed all of the issues that are before the court.
Your Honor, there was still G of the contempt and, oh, I think just G.
Let me go back to the motion, see what we got.
And then originally there was H as well, but I think that is off the table right now.
All right, and so that relates to taking, respondent shall refinance there was a paragraph in the court's prior order that indicated that the respondent shall refinance the property to remove petitioner's name from the mortgage within 60 days. Petitioner shall provide respondent with a quitclaim deed deeding over the property to respondent at the time of the closing of respondent's refinancing.
Yes.
All right.
Kevin never provided me with any information that he was closing or refinancing the property. I believe he never refinanced the property to remove my name from the mortgage. And so I didn't sign any quitclaim. I'm supposed to sign that after he gives me the information of the closing of the house, and I'm supposed to go in to do that, but I've never received any such information. So I don't believe that's ever happened.
Objection, Northwestern Bank provided Mrs. Karst all the documentation to remove her name from the mortgage. I asked that Mrs. Karst show at any time any monetary value from her towards the home.
Yeah.
So,
Ma'am,
wait.
I am well past due my schedule.
I understand that. I just have one clarification. Are you asking for any relief from the court as it relates to that issue?
Well, I'm not entirely sure what I need to do for that. Like, I need him to sign that, I guess. I need him to refinance the property, I guess, but I don't know if the court can.
All right, and so your
Do anything about that.
request is as it relates to his refinancing the property? Or at least whether or not he's done that, and your position is he hasn't provided you with any documentation showing that he's done that?
Absolutely, and if his position is that he did, I would like to see that. I've never seen any information from Northwestern Bank about the refinancing of the house, so.
All right, and so Mr. Shores, you've indicated that Northwestern Bank was to have contacted Ms. Karst about the...
They sent Ms. Karst the proper documents to remove herself from the mortgage.
I would like documentation of that, if that is a fact, because I never received that.
Well, I would like the court, in my financial circumstance, that any added court-related things that Mrs. Karst pay for at a fee of $15, which I have found out is an average court assistant or a lawyer's assistant's salary, because I cannot afford any more with what is occurring with my financial status from Mrs. Karst taking the disabilities. But is there a way, Your Honor, that I can ask that a debit card be made and that the money allegedly claimed that I owe goes into that account so then it can be tracked on how it is utilized? Because as I stated, Mrs. Karst is not working
All right, and so
and has not.
there is no requirement that she document or in law that says that she needs to document where that money goes. The money is to be paid, and so I'm not going to address that issue. So I think I have heard information as it relates to all of the issues before the court, and so at this point I'm going to take the matter under advisement, and I will issue a decision as it relates to the parenting time issues and the request for the finding of contempt.
What about the issue you were talking about, my ability to pay?
Well, that's what I asked you, Mr. Shores, if you had any information you wanted to provide to the court. And so we've now moved past that. And so
Excuse me,
I'm now
what?
taking-
When did you move past?
I asked you,
Again, objection.
Mr. Shores, we've addressed that. I've asked you
When?
numerous times
When did-
if you wanted to provide testimony on the issues, including your ability to pay. And so at this point, the record is closed.
Oh my.
I am going to take this matter
Objection.
under advisement, and I will
Judas.
issue a decision.
Corpus non judice.
All right, that will complete the hearing for today.